SJC-12246, Timothy Deal v. Thomas Turco.
Good morning, Ms. Kavan.
Good morning. Please, this court, Barbara Cabin, on behalf of Timothy Deal. With me today is Attorney Ben Keene, and we will be splitting our time. Courts traditionally assume an executive agency will carry out its ruling, but where, as here, the undisputed facts document that DOC is continuing to circumvent this court's ruling, this court is warranted in ordering additional procedural safeguards of adequate notice, access to counsel, and a tape recording of the classification board proceeding in order to ensure the individualized determination required in Deal. Implicit in the concept of this individualized determination is that it was a fair and reliable proceeding. And right now, as it's conducted by the department, without these minimal procedural safeguards, juvenile lifers like Mr. Deal have no way of contesting or rebutting, refuting the factual inaccuracies or, in fact, the subjective, prejudicial statements that become the justification for denying their transfer to minimum security facilities.
Do you disagree that the department has changed the procedure by which it classifies juveniles after Deal 1?
In many ways, what they've done is they've changed their procedure and made it more difficult. But the proof is in the pudding.
Well, the question is, did they change it to avoid the problem that was identified in Deal 1, that is to say, the categorical exclusion?
No.
I read the affidavit, and that impresses me that they've done something, unless you tell me that that's not the case.
They changed a lot of the procedures. They jumped through a lot of hoops. But the outcomes is where we have to look, because what happened before, if I can just take a few seconds and just outline the procedural steps that occurred here. Prior to July of 2014, 100% of juvenile homicide offenders were denied transfer to minimum security facilities, even when they qualified, based on what the department refers to as non-discretionary overrides, code Z and F. They basically said, based on their crime, they can't go to minimum. In 2014, the Massachusetts legislature, responding to the changing legal landscape for juvenile offenders, said, DOC, we're limiting your discretion as applied to this cohort. You can no longer do that. Then DOC has a new round of classification hearings for this cohort. And lo and behold, instead of using the non-discretionary override, they now change and use discretionary override R, code R, which basically is the nature of the offense.
But they can use that. I mean, Deal didn't preclude the department from using those discretionary factors, right?
Correct, but what the court did in Deal 1 was go further and say there has to be an individualized determination. And what happened at that stage was that 100% again were excluded based on Code R. And now they've gone through this whole elaborate procedure, and now we have 90% that are excluded based on the use of discretionary overrides.
So how do we know that that's not the way it's supposed to be? All we can do is go by the two classification reports that we have, and there's reasons. Deal said, okay, you can't just say what the categories are, but it seems to be that this is a little bit different from what they had been doing before. The outcomes may be the same, but I didn't understand Deal to mean that the outcomes had to be different, just the procedure has to be different.
I think what Deal specifically said was that there has to be an individualized determination, and that the reasons have to be supported in the record, and that basically what we have here, the only way we can tell right now, because there is no record anyone can review, because there is no recording, because there is no record anyone can review, we have to just look at the outcomes, and we have to look at what the data tells us, and we have to look at what national best practice standards tell us about the use of discretionary overrides. So what we know is that, as they reported in their affidavit, they had new classification hearings for 42 individuals. 38 were immediately denied. Now, national standards of best practice say that when you're using discretionary overrides, they should occur in about 5 to 15% of the cases. Okay. I understand that DO says, well, okay, our data shows we only use discretionary overrides in 13% of our cases overall. But this is a unique cohort. The Supreme Court has recognized juveniles as a distinct cohort. This court has recognized it as a distinct cohort. And there is precedent for looking at distinct cohorts within the classification process.
Oh, I'm sorry.
Go ahead.
I was just going to ask you on that point. When you're talking about, before you said 100% and now it's 90%, on that 100%, was it the same cohort or were we talking about the larger cohort?
No, it was the same cohort of juvenile homicide offenders that I was talking about.
So you're comparing apples to apples, in other words?
I am, indeed.
And you're saying that now that the DOC is comparing apples to oranges?
When they talk about the 13%?
Yes.
Absolutely.
Okay.
Because what they're basically saying is they're masking what's happening with this particular population, this very unique cohort. And the fact of the matter is we have 90% denied minimum security placement based on the use of discretionary overrides that have never been used in the past for this population. Code U. If you look at what DOC reported to the amicus, and they actually outline, Code U is used in approximately 1% of the cases to exclude the general population from transfer to minimum security. For our population, it was used in 83% of the cases. The numbers are out of whack. And what it really points out is that all of this procedural steps they're taking is a pretext. It's still a pretext to basically ban juvenile homicide offenders overwhelmingly from minimum security placement, even though they qualify on the objective measures. So before they were non-discretionary overrides, E and F, that kept them out. Then that was, the legislature said no more, so then they went to Code R. This court then said, you can't just use Code R and S. So then they went through this whole elaborate procedure, but when we look at the outcomes, what we have is 90% excluded, and in fact, when we look and compare it to national standards, when they said it should be between 5 to 15%, they said when you use discretionary overrides, typically what we would expect based on best practice standards, is that 50% would be going to a higher security, 50% to a lower security. Well, in fact, here again, the actual practice of DOC is to use the discretionary overrides to make sure that the 90% still are maintained in minimum security. None of it is a downward extension, it's all the upward extension.
Counsel, can you explain to me the cohorts in Massachusetts compared to the cohorts in the national, with the national statistics? How do we know those are exactly the same, that they're for purposes of comparison?
Well, when we talk about the national, let me just back up a second. In general, when the objective classification procedures were put in place across the country, the primary cohort was basically male offenders that these objective systems were developed on. And then what happened was the researchers started looking at females as a separate cohort, and they said the females look like they're basically are overclassified. In other words, they're not going down to minimum, they're going to staying in medium or higher. And they said, this is a separate cohort, you've got to adjust for this. So when we look at this particular cohort, okay, we're looking at just the juvenile homicide offenders. When the DOC reports that their number is 13%, they have actually detailed to us that that's the whole population. I assume it includes the females, but males, females, whatever.
The whole juvenile population?
No, the whole adult population
adult
that's in prison. Right.
And then I suppose my question is maybe a little bit different in terms of looking, let's just take male offenders, male juvenile offenders. Mm-hmm. We want to look at male juvenile offenders and say, based in Massachusetts as compared to onto the national average, we have a difference. Is there anything leading up to the conviction of a male juvenile offender in Massachusetts that is different than that would send somebody into that cohort nationally? Or are all factors controlled for, such as differences in statutes? and differences in terms of how we apply law here?
I can't answer that question. I don't know how they address the cohort nationally.
I'm trying to figure out what precisely are you asking us to do? Is your argument that the remedy that we set forth in Deal is inadequate to address it, that this is analogous to a discrimination case where we set forth a remedy because of the DOC's failure to comply with the statutory directive to not, the placement shall not be categorically barred based on a life sentence? Or are you asking us to do something else?
Yes, I'm saying you didn't go far enough, that basically what we now have is an individualized determination, but we have no way to know in fact that it's based on facts that can be actually, you know, these proceedings are in fact subject to Chapter 249, Section 4, certiorari review in the Superior Court, but there's no record. There is no way to take it up. So right now, what we're asking you to do is put in place some procedural safeguards, primarily access to counsel. If they have counsel, let's counsel come, but most importantly, recording of the proceeding, so that we actually have a record.
Something that should be done by the legislature. Why should that be done here?
No, it should be done here because this court, basically in Deal 1, went a little further. They didn't just stop and say the proceeding contravenes 72B, the amendment to Section 72B. What the court actually said was there has to be an individualized determination, and there has to be a writing of the supporting documentation for that decision. It can't just be code R&S. You went further, but basically what's happened is now we have a procedure that is basically a pretext.
Did I understand you to say that you agree that the procedure is individualized, but the problem is that there's no check on the propriety of the procedure or the vitality of the finding as a result of the procedure?
I can't even say it's individualized because there was no record for me to review, even in my own client's case. Because there was no tape recording of that proceeding, I can't really make that decision. I can tell you what my client said. I can tell you that I tried to come. I can tell you I was denied access to come, but there is no record for me to review. I can tell you that when my client's case, as he said to me, I thought we won in Deal, and I think I'm worse off now than before, because suddenly an indelible part of his institutional record includes this statement by the decision maker, and I do want to address that decision maker in a minute, that in fact he minimized the crime, that he was blaming other people for his behaviors, and as he said to the parole board member who questioned him about that, he went in thinking it came out of that hearing thinking it went one way, and then read a decision that didn't coincide with anything he recalled. And what we have to remember here is that the decision maker is not the classification board. All they do is make a recommendation. And then it goes up to the commissioner's designee, who hasn't interviewed that individual, and I assume hasn't heard a recording of the proceeding, since I can't access a recording of the proceeding. And so we have a situation where the actual decision maker has not been in that hearing, did not hear any of the give and take between the classification board and the prisoner, and then writes a decision. And in Deal's case, it really is glaring, because the decision she writes is basically a cut and paste of what the class board wrote, and talks about his minimizing, and talks about his presentation as the basis for the justification of denying him access.
I thought you said there was no record of what happened.
There is no tape recording. That's exactly right. What she's got as the record is the classification board's decision. And if you look at their decision and you look at what she wrote, it's the same thing. But yet, what did she review?
This cohort of juveniles should have the right to appeal the classification decision. Nobody else has that right, but this cohort does, you
No,
think?
everybody has that right because of the
No,
administrative.
I mean in court. You said
I'm saying-
certiorari.
I'm saying that according to the Administrative Act, everybody has anyone who's classified could theoretically go to Superior Court. It very rarely happens.
You can?
That's what I've been told, according to 249, Section 4, absolutely, that in fact it's something that is a vehicle of review for an administrative
So
hearing.
this went that way?
No,
was-
it hasn't
did
gone
not.
that way.
No, there was no, okay.
We actually went back to the single justice asking for some modification there, and then it got reported for deal 2.
Okay, you can pass the baton to Mr. Deal.
Mr. Deal.
Mr. Keen, I'm sorry. I don't know who Mr. Deal is. Mr. Keen, I'm sorry, I don't know. All right. I have the right number of syllables, but the wrong name.
All right. May it please the court, Benjamin Keene on behalf of Jeffrey Riberio, who was also one of the original petitioners in Deal 1 and has intervened in this case, which is here on reservation and report, by the way. And with me is Attorney Dulcinea Gonzalez, who also represents Mr. Riberio. Let me begin by addressing the second of Justice Hines' question, which was, as I heard it, you take a look at the written decision, the record such as it is, and how do we know that that's not how it's supposed to be? And I get that because this is a coherent decision. It's relatively detailed. It makes references to points that seem germane on their face. There is nothing about it that on its face appears arbitrary or capricious or plainly erroneous. But they won't let a tape recorder into the hearing room.
What if they did? So
Then we would be able to show
No,
you.
I understand that. I understand that. But I'm saying deal 1 is suitability on a case-by-case basis, not a categorical denial of minimum security. And now I think it's either 88 or 90% are being denied right now.
Right.
But all people who have been convicted of murder, 10 to 12% are getting to minimum. So if,
That's the overall rate,
okay.
is about 13%,
Including adults.
including adults, including non-homicide.
So for juveniles, it's 10%?
It's 10% of this cohort.
Right.
DOC has made perfectly clear that they don't believe anybody who is doing time for a homicide belongs in minimum unless and until they have a definite release date
That can't
from the
happen because
parole
of deal
board.
1.
It's still permissible as to adults, but it's not permissible, and DOC has accepted that on its face because this court has said so. So instead of using discretionary overrides T and S to exclude virtually every objectively qualifying juvenile homicide offender, now they've dusted off discretionary override U, which I hadn't even heard of until this, to reach virtually the same result. And I agree, and this was, we are
Refresh my
not,
memory, what does U refer to again?
it refers to, relates to safe and orderly operation of the facility. Nobody who, none of these cohorts pre-deal 1 had that finding used against
But
them.
it is,
And now 80,
it's there though, right? So
It
you-
exists.
You can use it, and you're not saying that there's, that the DOC shouldn't be allowed to use discretionary override. You're just saying that there should be procedural safeguards, is that right?
absolutely correct.
And so in this case, you're just looking for a rehearing?
Yes, and there will be new hearings. They, if they are not, if they are denied, if they're deemed unsuitable for minimum, even though they objectively qualify, then under existing regs, they get another hearing in 6 months. We want to know when that rehearing is going to happen. They say, just look at the regs, you can find out the date yourself. No, it's not the date, they have lawyers.
So what's the hook here? I mean, what do we say if we were to agree with you? What is the law that requires us to impose these different procedural safeguards? What authorizes us to do that?
So, 3 things related. One is Deal 1 itself. Deal 1 says for 72B to be given effect, given DOC's undisputed track record of how they believe it should be implemented, we need to impose some protection, individualized hearing.
Don't we
Second,
have to know that they haven't done what they're required to do under Deal 1? I mean, that's step
Yes.
1 before you get to procedural safeguards, right?
Well, I would say no, because without a tape recorder or a legal representative in the room, we have no way to show under 249.4 or any other legal means what we have alleged, which they have made up reasons for deploying these discretionary overrides.
Well, see, that's a different question, whether the decision is justifiable. That's a different question from whether or not they've gotten an individualized review. That's
Gotten an individualized review.
okay.
They have got,
They have got that.
Oh, they took that to heart. You want an individualized hearing? We'll give you an individualized. They went back and gave them super hearings. They brought in 3 people from downtown. They gave them mini parole hearings, as each and every one of them was told.
So
They were
that part of deal
aggressively
one was
interrogated.
complied with.
It was complied with.
Okay.
But what actually happened during those hearings? Trust us. What do they have to hide? Why don't they want a tape recorder in that room? Why wouldn't it be a more reliable and fair hearing if a lawyer who has this person's best interest at heart were allowed to be there?
Well,
What
I
is
get that, but I'm just trying to figure out where do we get the right to say that they should be required to do that? That's what you're not
72B.
explaining. Where does it say that?
It says that the impediment that previously existed to prevent juvenile lifers from getting to minimum, their life sentence, may no longer be used by DOC. Implicit in Deal 1 is that they may not use their discretionary overrides pretextually to get to the same effect, and they are.
Well, but are you saying that 10% did exist before also, or is that?
No, it was 100, it's improved.
Okay,
It's improved. It's got,
That's what I'm having trouble understanding. Did it go from 0% to 10%?
for this cohort, it was pre-Deal 1, it was 0. 100,
Now is it now 10%?
yes,
Okay, so
4.
that's why I'm confused by all the skies falling down. This is a pretext, it's categorical denial. Well, let me just so you can focus on it, because I think there's a lot to what you say about the tape recorder. But to go from 0% to 10%, we are now saying from that, we have to say that this is still categorical denial.
It's a de facto categorical denial based on the fact that they are juvenile serving homicide sentences. They are getting special treatment that other prisoners don't get, that is resulting in a way disproportionate use of discretionary overrides to bar them from minimum. It is no different as a practical matter than the rationale that they came up with in Deal 1. It was still, they were just more honest in Deal 1 and said, we don't send anybody to minimum unless they have a release date from the parole board.
So basically, the 10% is negligible in your view, and not something that suggests that there has been, in fact, compliance.
There is too much smoke to take that and go to the bank with it.
Okay, and your sister brought up the national statistics. What were those again on the juvenile offenders?
See, I don't think there are any national statistics which pertain to juveniles per se. And this is a point that's made in the reply brief. This is the same problem that existed with female offenders.
Well, what about this? This argument that you're making is analogous to the argument that used to be made a long time ago in discrimination cases. It's a discriminatory impact. But the courts have said, well, you can't prove your case with a discriminatory impact. You have to prove a discriminatory intent. And that kind of feels like what we should be asking you here is to show not the raw numbers, the 10%, but that there's something wrong with those numbers because the department isn't doing what it's supposed to do. And I don't know how we know that.
Because all we're asking for is a tape recorder and a lawyer.
No,
and if
no,
we
no,
had the
but
tape recorder,
before
we would
you
be able
get
to
there,
show.
we have to know that that something's wrong. We just can't say tape record.
Well, I think you can, in light of their track record, in light of their promiscuous use of discretionary overrides as applied to this cohort, in light of their stated belief that nobody who's doing time for a homicide belongs in minimum unless the parole board has given clearance ahead of time, because it's not going to be on our head if somebody were to walk away. We are not alleging intent because we cannot prove it. But if we had a tape recorder which said, you know, Mr. Deal, I don't like your attitude. I don't like your attitude because you don't take responsibility for disciplinary reports.
So where's the statute that says you can appeal that? Even if you got a tape recorder and you got all this stuff, what do you do with that
Well,
if you don't like the result?
249.4 is an
249.4 says you can appeal a classification decision?
it applies more generally action in the nature of certiorari to administrative final decisions for which there is no other available appeal.
But don't we have statutes that say that classification decisions are within the purview of the commissioner?
Yes.
I've never heard of a prisoner
Well-
suing over the classification.
Oh, they have happened. They have been very rarely successful, and part of the reason is because this action in the nature of certiorari involves a judicial review of a record to see if it was arbitrary and capricious. And the review here that is available for Mr. Deal, for example, is the review that says, well, it's coupled with his presentation to the board. How do you prove that was arbitrary and capricious if there's no tape recorder that shows him being polite, taking responsibility, having a contrary view of the facts to what the record has contained? I'm sorry, I didn't mean to cut you off.
No, that's all right. I think I answered my own question.
So did you finish answering the question about what, I think Justice Hines asked, how are we authorized to do this? And you said there are three ways. One is by deal itself.
Right.
And I'm not sure I heard what number 2 and number 3 are.
Well, they're related. 72B itself, it is part of the court's responsibility to ensure that this statute, that the legislative intent is affected in a way that doesn't defeat the statutory purpose. And third, and this goes to really their sort of overall argument that, you know, Article 30 prevents you from doing anything here. Well, there have been many instances in which DOC in particular has been intransigent in the face of judicial decisions as to how to treat prisoners. These are not cited in the brief, but I can give you a cite to one case, Blaney, 374 Mass 337. And there are others which say that, you know, along the lines of just the discrimination cases where, you know, federal judges would continue to say desegregate, and state officials or local officials would come up with, you know, increasingly incredible reasons for not complying. There is a judicial authority to do and decree what is necessary to require the state to obey the law. We are not making a constitutional claim yet because we can't prove discriminatory intent. We are just saying that this court has the authority, indeed the responsibility, to give this cohort, which is supposed to be given some statutory protection under 72B, the ability to show, if necessary, that their hearings have been unfair, pretextual, and unreliable. And I've gone over time, but I haven't had a chance to speak to my client, Mr. Riberio, who was denied based on Code U and another code, and based on the classification board's statement that he refused to do a treatment program that had been strongly recommended to him by the parole board when they denied his parole. Well, he says he did not refuse, just the opposite. Now, this is important, the reason we're here is because of the interrelationship between the classification record, which is littered now with this negative stuff, and the parole decision. This information goes to the parole board.
And it has to.
It has to. There's a statute.
So to the extent that it's argued to the contrary, that it has no effect, what's the point of sending it in the first place? If it has, what's the point of having to send it in the first place if it has no effect?
Yes. Well,
I'm sorry, I thought that the department was arguing that it had no effect.
they do. They do make an argument that classification decisions have no effect, and they sort of misconstrued the argument, I think. The point is that this is evidence, raw evidence, that the parole board considers in deciding whether somebody is suitable for parole. And it's unreliable and unfair. And it is true, as a technical matter, that the fact that somebody, a parole-eligible juvenile offender, is in medium as opposed to minimum is not per se a reason why the parole board will act negatively. But that's not the point. The point is, in Riberio's case, the parole board told him, do this program, and DOC, falsely, we allege, says that he refused to do the program. In terms of his next parole hearing, there is little that could be more prejudicial than to have a classification report that essentially says he was thumbing his nose at the parole board's recommendation.
Okay, thank you.
Thank you.
Mr. Anderson, still good morning.
Good morning. May it please the court, Charles Anderson, I represent Thomas Turco, who is the Commissioner of the Massachusetts Department of Correction. The uncontested factual record shows that the department fully, fairly, and promptly implemented the deal.
What is that record, please?
The record is based in the record appendix, the classification reports of Mr. Deal and Mr. Roberio. You have the affidavit of Lori Cressy detailing the steps that the department took following the issuance of Deal 1 and the processes which the department followed in order to individually classify each member of this cohort.
What's wrong with providing a tape-recorded?
The commissioner has made decisions based upon the interests in question as to what proceedings within correctional facilities receive tape recordings. As for an example, the department permits disciplinary proceedings to be recorded. And the commissioner does that in line with the interests at stake in those particular hearings. A disciplinary hearing, which could result in potentially the forfeiture of statutory good time, would have an impact upon an inmate's liberty interest, and consequently, these proceedings can be recorded. Classification in difference to this doesn't contain a liberty interest. An inmate does not have a liberty interest in their classification. So it basically just reflects the commissioner's determinations as to the types of hearings that are conducted within his facilities.
But can't the classification hearing lead to a interest in a liberty interest? If somebody is not fairly getting their classified, aren't they ultimately being restrained or constrained in the future? Whereas if they had been categorized differently or classified differently and had the due process concerns cited, perhaps their liberty interests might be a little more available to them later. Isn't that the real thrust of this?
I'm not sure I understand liberty interest available to them. Do you mean by in terms of being paroled? I'm sorry.
Eventually getting paroled because they've been able to take advantage of programs in the less restrictive environment.
Well, the Department of Corrections' main breadth and bulk of programming is at medium security. It's not in minimum security.
Okay.
So that, and the department expects that inmates will do the bulk of their rehabilitative programming while in medium security. Because as a general rule, those inmates who are in minimum security spend their time working, not so much programming. And some programs that are available in medium security simply aren't available in minimum security. So the expectation is that the inmates will do the bulk of their rehabilitative programming while in medium security.
Let me ask you about your own CMR. CMR 420.08, subsection Q, quality assurance. All classification board recommendations shall undergo a quality assurance process which involves a review by the institutional director of classification or designee. The designee must not have been a member of the classification board, who shall review the report for completeness and accuracy. How can somebody who was not present at the classification board review the report for completeness and accuracy when there is no transcript or tape recording of that board proceeding?
What they're reviewing in the classification proceeding is ensuring that the recommendations that are being made are based upon facts that are contained in the inmate's record. So that information would be contained in the other parts of the classification report itself, as well as information that's available on our inmate
To the
management.
extent the report relies upon statements made during the course of the board proceeding, which appears to be the case here, correct? With regard to Mr.
Yes.
Deal? How can there be a quality assurance if they're relying upon things said during the hearing without there being any record of the hearing?
I don't believe the quality assurance audits are done of statements made in the hearing, but rather the rationale made by the classification board in making that decision and making sure that that is supported by facts contained in the
But if-
inmate's record.
Well, but if the rationale is statements made during the course of that hearing, how can there be a quality assurance with regard to its completeness and accuracy?
Well, in that circumstance, I would expect that the auditor would be able to speak with those members of the classification board to discuss what happened at the hearing and what the statements were that were made.
All right, let's turn to subsection H, inmate appeal. Where there is an appeal, the decision maker, I guess, is the correctional program officer, is that correct?
For a standard classification review, the one that's done annually, a correction program officer does the review of the inmate's record and makes a recommendation. This process no longer applies to juvenile lifers, but the way it works is
And
that
with regard to juvenile lifers, let's focus on them. To whom does the appeal go?
for juvenile lifers, they are now being reviewed every 6 months. As long as the CPO reviews them, they qualify for minimum security based on their point-based score, no restrictions apply. They're being reviewed by 3-person classification boards and the commissioner's designee every 6 months.
And is that a recommendation to the commissioner?
Yes, the commissioner.
So the commissioner is then making the decision based on the recommendation,
Correct.
but it's the commissioner's responsibility to render the decision.
Yes, or I should say the commissioner's designee. The commissioner has several designees who make the decision based on his behalf.
Okay, but it's somebody not present at the hearing.
That's correct. The commissioner,
How can, if there is an entitlement to a hearing, but the decision maker does not have access to what transpired at the hearing, what is the purpose of a hearing?
the purpose of the hearing is in accordance with Mass State Law. 127, Section 20A talks about classification boards being appointed so as to have these hearings and make recommendations for classification. The Mass State Law also provides that sole classification authority is in the Commissioner of Correction. So the Commissioner regularly makes determinations on hearings for which he has not participated in. As another example,
Well, I understand that, as do Superior Court judges on 30A review, but we do it based on the record below.
yes, and the record,
Have no record below as to what was stated at the hearing.
we do have a record below on what was stated at the hearing because it's contained in the classification board's recommendations. And that's what we had in this circumstance. The record upon which the commissioner's designee makes a decision also includes the appeal, the administrative appeal that's been filed by the inmate.
And that's you'd be looking for arbitrary and capriciousness in that? Is that what the reviewing court would be looking at in that appeal?
It's a reviewing court in a 249-4 case, I think based upon this court's decision in Hastings, does look to see arbitrary and capricious or inconsistent with the plain terms
But the
of law.
commissioner's determination is de novo. The commissioner is not using an arbitrary and capricious standard with regard to the recommendation, is he?
I'm not quite sure I understand the question.
An inmate appeals to the commissioner. is the commissioner making a de novo determination, or is the commissioner determining whether or not the classifications board finding was clearly erroneous or otherwise arbitrary?
No, the commissioner doesn't make those types of findings. What I'm saying is the commissioner takes into the account the recommendation, the appeal. The recommendation is solely a recommendation to the commissioner. The commissioner is the sole.
The commissioner is the sole decision maker.
Correct. Yes, the commissioner makes the sole decision here and does it.
The sole decision is being made by somebody who is not present at the hearing and has access to the hearing only to the extent that persons at the hearing included in the report.
And the commissioner's designee has access to all of the records of the inmate upon which she's making that decision. So it's not just an issue of what's being said at the hearing, it's an issue of what information is contained in the record and upon which the classification board has made recommendations.
Now,
based on-
if somebody goes to, somebody goes to a classification hearing, can the person's classification be increased or merely decreased?
Anytime there's generally under the regulation, a three-person classification board is convened when there's after the CPO's review, the CPO believes that the inmate can go somewhere else, either to higher custody, lower custody, or to a different facility of the same custody.
But does the board have the authority, regardless of what is said below, to say, you say go lower, we say go higher?
The classification board will make that recommendation. The way it works is that the correction program officer will calculate the point-based score as well as any applicable overrides or restrictions, and then recommend to the classification board what the classification of this person should be.
Okay, but I guess my question is with regard to a classification hearing, is the inmate at risk of being classified to a higher security facility?
Well, that's how it would be done, but the inmate would be aware of that in advance because the CPO in his interview with the inmate would say, I've calculated your point-based score, and because of that, you're at risk of being transferred to a higher security facility.
Because you're entitled to legal representation where you're being considered for transfer to a higher security facility.
At a classification board. So in the circumstance where a CPO on review and interview with the inmate says, I've calculated your point-based score, you're at risk of going to a higher security facility. At that point, what happens is that the institutional director of classification schedules a three-person board, and the inmate does have the ability to have a legal representative present at that board.
Who is limited to make a statement on behalf of the inmate.
That's correct. But our regulation also provides that for any classification hearing, counsel can make a statement in the administrative appeal stage of it. So counsel, and we routinely have counsel weighing in on administrative appeal and classification decisions.
I'm sorry, just a second.
No, I've had my question answered.
Mr. Anderson, why isn't it part of implementing Deal 1 and implementing 72B? Why wouldn't we say, well, in order to be able to tell if this is not categorical denial, or what 10% means, that there needs to be a tape recorder in there?
Well, I think what the court has to do is look at what is the legal claim that's being presented here and proven, and what does the record show in the case before determining that the commissioner should have to make policy decisions which he hasn't chosen to make.
But if we're looking at this and saying we can't tell from this record, we can't, you say it's a record. Justice Gantz has just shown you all the reasons why it's an inadequate record.
It's the record that's under the department's duly promulgated classification regulation. I mean, these classification proceedings are reviewed under certiorari standards in Superior Court, just as our disciplinary proceedings are. There's no...
But if somebody's claiming that things were said that were not said, how does anyone ever get at that in terms of finding that, you're saying that the decision maker here is going to rely on what the board found, that to the extent what the board found is based on documents that anyone can review, I see that. But to the extent that the board is saying, well, we find this because he didn't engage in this program. He decided not to decide, he testified that, and that's not what happened, or that wasn't the testimony. There's no way to be able to get at that inaccurate finding because the person who's making the decision ultimately wasn't there and can only speak with the people who've made the finding that's alleged to be inaccurate. So there's that intrinsic difficulty.
There is that intrinsic difficulty.
He solved by a record that was more complete, that includes something like a recording.
And, you know, sometimes, like with Di Giambattista, the record actually is supportive.
Right, it has worked out very well for a lot of people because, in fact, many trial judges are embracing of the recordings because they, in fact, show it happened the way that they said it happened.
Well, to the extent that decisions are made based upon statements,
Which appears to be, at least in one of the cases here,
it appears that in part in this case, that decision was based upon statements which Mr. Deal referred to as a misunderstanding in his parole board hearing. So, I mean, given the fact that we have three people who've made a recommendation on this, and Mr. Deal himself characterized it as a misunderstanding. I mean, it's the difficult. There are ways that this can be corrected, not only by administrative appeal review and court review, is that in that the regulation provides for classification reviews every 6 months. So because this hearing that's been alleged to have been relied upon statements has concluded, Mr. Deal, it's not Mr. Deal's last classification proceeding. He receives one every 6 months. So if in the event that the review cannot be fully realized in court, he has a new review every 6 months. The regulation provides for that.
right, but what does that get him if he is going to have that be part of his record? I mean, the record presumably of the former classification hearing will be before the board again. With the let's just say arguably misunderstood basis for the findings that appear to have been made.
Well, that record as well as other classification reports will be available to the parole board. And the parole board has access to information regarding an inmate's program participation, their disciplinary history. They have access to the facts of an inmate's records, not just whatever characterizations there are, you know, made by the recommendation of a classification board. So the parole board, is part of its, you know, independent duty to determine whether or not somebody's suitable for parole. They have access to all the information that the commissioner does in making a classification decision. And because of that, you know, they are able to, as it appears that Dr. Bonner did with Mr. Deal's hearing, is that they're fully within their rights of being skeptical or disagreeing with the rationale given by classification boards and their recommendations. So so that in terms of the records, the parole board has the same opportunity to get the information. They have the same information available to them that the commissioner does. And
Which may be based on factual error.
there's a possibility, they could be based on factual error.
Because of reporting as to their impression of what happened at a hearing that may be mistaken. Because there is no record of what happened to be able to be reviewed against what those findings are.
The board will be able to weigh this information in line with the information it receives concerning from the inmate's records in terms of being able to make a decision whether or not an inmate is suitable for parole. Now, the evidence before this court shows that the parole board does not consider an inmate's security level in determining whether or not somebody is suitable for parole. What they do consider, however, is an inmate's rehabilitative programming and their history.
So why are the reports forwarded to the parole board?
The reports aren't forwarded to the parole board. The parole board has access to the department's inmate management system. The institutional parole officers at each facility have access to the department's inmate management system, so they can get whatever information they want out of the inmate management system. We do not forward records to the parole board anymore except upon request. They have electronic.
Keene is wrong in what he told us?
I'm not,
Mr. Keene is wrong in what he told us, that they're required to be forwarded to the parole board?
no, the state law does require that Massachusetts, that the Department of Correction provide its records to the parole board. The way the department carries out that statutory obligation is by giving the institutional parole officers electronic access to our inmate management system. So rather than printing out and forwarding paper copies of the documents, they have access to our electronic database so that they can get whatever records they wish in preparation for parole hearings. So that's just how that statutory obligation is carried out. It's not that we're forwarding the records, it's just they have access to the records.
Now, those who have been determined through their score to qualify for minimum security do so because they have 6 or fewer points with regard to the scoring system, correct?
Correct, and as well as not having any restrictions that apply.
And there are 3 ways in which they can get points scored against them. History of prior institutional violence within the last 4 years, that's a 0 to 5.
Yes.
Number of guilty disciplinary reports within the last 12 months, 0 to 4. Most severe guilty disciplinary report within the last 18 months, possible score 0 to 7.
Yes.
So on those 3 dimensions, they could get 0 to 16 points.
Correct.
But the people before you who have had no more than 6 points.
Correct.
So can you explain, I'm looking to the Prisoner Legal Services amicus that says that 83% of the persons post-deal who went before the classification system were found to be overridden by Code U, which is those whose behavior, while not always negative enough to warrant disciplinary action, may serve to threaten security or undermine the exercise of proper control or maintenance of order within the institution or other correctional facility. How can 4 or 5 people who score so low on these 3 dimensions meet Code U?
Those 3 dimensions take into account inmates' recent disciplinary histories.
The last 4 years is one of them.
That's correct. And the reason for the use of Code U, as you can see from the addendum, which contains the commissioner's designee decisions for this cohort, is Code U has been used because that is ultimately what the commissioner's designee has to determine, is whether or not the transfer of this person at this time to minimum security would negatively impact the safety and security of that facility. And for each of these decisions, and if you look through the addendum at the rationale, you will see that Code U has been used in conjunction with other override codes so as to explain that, for example, Code R, nature of offense, what about this person's offense, what facts about this person's offense haven't they addressed in terms of their programming, that if they were transferred to minimum security, they would cause a threat to the safety and security of a minimum security facility. So if you look at the decisions that are made in the addendum, you'll see that Code U has been used in conjunction with other codes. And I think with possibly 2 exceptions, it has been used in conjunction with other codes, not in itself.
But but Code R is the severity of the offense, but all of these are lifers. They've all, maybe all or nearly all of them have committed, have killed somebody.
Yes. Well, it's...
So this can't be, the fact that they killed somebody can't be sufficient.
And it isn't.
Code R.
No, well, Code R goes back to the nature of offense containing a seriousness which cannot be adequately captured in the point-based score. Murder is not the only crime for which somebody receives the highest point-based score based on the severity of the current offense. But the way that the Code R has been used in these decisions, and that's contained in the addendum of the amicus brief, is that there are certain factors with regard to each crime that the department expects that the inmate will engage in rehabilitative programming so as to address those factors before they're transferred to minimum security. So Code R is not based on the mere fact that somebody has murdered somebody else, but rather the classification board and the commissioner's designee look at specific facts of that crime.
Like
say-
substance abuse, for instance?
Exactly, like substance abuse, criminal thinking. The department has a wide variety of rehabilitative programs. And so in making that decision based upon Code R and Code U, it reflects that the department is looking that inmates address their criminogenic needs via rehabilitative programming, and they do the bulk of that while in medium security.
But Code R doesn't speak about rehabilitation unless it's changed. It says the facts or notoriety of the offense presents a seriousness that cannot be captured in the score. It's focused purely on the
That's right, and that's why Code R is being used in conjunction with Code U, is by showing the facts of the offense and tying it into Code U, which talks about the safety and security of a facility, and looking at those two codes in terms of what the commissioner's designee's decision says. It ties in, as is required by Deal 1, the overrides with the decision. It provides a written rationale for these overrides, that there are facts about this particular crime that need to be, the root causes, the criminogenic factors need to be addressed by rehabilitative programming while in medium security.
All right.
Can I just ask one last question in terms of, I take it you have all of the equipment necessary to record these hearings if that were to be the ruling of the court?
Each facility does have recording equipment that is used for disciplinary proceedings. Okay, thank you.
Thank you.